Hey, Brian Parker here with another exciting video. Along the vein of our current videos about plunking and setting up your counter affidavit, but more importantly, this new iteration of looking for the linchpin. I've got one today on Midland Credit Management. It's a Florida lawsuit, but I do more than one state litigation, so I recognize they're all basically the same, even the mini Miranda warning. So let's get started on the linchpin of a Midland Credit Management lawsuit. First and foremost, I have to advise you that in this case, it is my client's case. As you know, I like to have you look at cases I'm actually filing. Excuse me a second. Real good. And so that's more important to me as far as giving you so I give you an actual case, actually done, so that you can apply it with your own state laws and facts. In this case, it's a simple complaint. Let's put up the complaint, Cindy, the whole thing, Shazamski. And you can see it's a 7-paragraph complaint. It lacks real substance, but what do we look for when we're looking for the linchpin? We look for the linchpin, which is that part of the lawsuit that if it's removed, the whole thing falls apart. So in this case, we're going to find what that linchpin is and how we kill their whole case. And of course, I haven't said this in the last couple of videos, but what do we use to kill their case? What is it? What is it? Right again, we use our own documents against them. So let's look at it. So Cindy, put up paragraph number 1 of the complaint, Shazamski. And right there, they are saying, will you, debtor, my client, belong in this court, and we do not exceed the jurisdictional amount. My client, funny to say, does not live in this district court and lives in a court district that's very close to him. And the fun part is Midland Credit knows that because they have been sending him letters to this place that he lives in and avoided filing against him in the court right down the road from him. That's the law. And filed it in a district he has to drive an hour to get to. So in your counter affidavit, you say, as I did, I live in the jurisdiction of, in this case, North Dade Justice Center, close to my home at an address MCM, has all their paperwork in the lawsuit and in letters sent to me. I don't belong in this district. So that's part of your counter paragraph. But it's not the linchpin per se. So now let's look at paragraph 4. Let me tell you, Lynch Pin Alert, Lynch Pin Alert. So Cindy put up paragraph 4, Shazam, and it says, plaintiff subsequently acquired all right, title, and interest to defendant's account. A copy of the chain of title and or bills of sale to plaintiff is attached. So there's your linchpin. If that goes away, if the proof of said allegation goes away, case goes away. So that's what we're doing. That's our linchpin. Let's go get it. So here's the bill of sale, Shazam, and that is saying that Synchrony Bank, formerly known as GE Capital Retail Bank, RFS Holding, LLC, Synchrony Card Funding, LLC, Retail Finance Credit Services, LLC, collectively the seller. So put 100 people up there. They're always trying to morph what securitization has done to the original debt. And so instead of having 4 or 5 entities, you just have a seller. So it's a hiding the ball type of thing. So we do the opposite. We focus on that. So the 3 problems with this document that in paragraph 4 says is everything to this case are the following. Cindy, put the 3 problems up for the kind folks. And number 1, it's signed by your old friend, you've heard me talk about her before, Lynn Fisher, the woman of many jobs and many hats, but really only has one. And here she is signing, by the way, in November, when this is supposed to be an October bill of sale, And she is authorized signatory, SVP, recovery operator, business development. She works in business development. So does a Daniel Wershaft. She's an authorized signatory, and she's also a vice president. Good for her, but that's not true. So when you see something like that, you have to have an authorization of that person to sign for the seller or the sellers for that to be legit. Number two, no proof attached to the lawsuit showing how all these entities obtained the debt to sell it, meaning that's what I was telling you before. They want to condense all these many owners because of securitization into a seller. So it's a seller sold to a buyer. No. In your counter affidavit in your answer, you spell out that these are not just a seller, they are sellers. And there's nothing showing how these entities obtained the debt and were able to assign the debt. So how would they assign the debt? How were they able to be sellers of the debt? And then look at paragraph 5 in the lawsuit. Shazam. Plaintiff notified defendant of the assignment more than 30 days before the initiation of legal action, pursuant to Florida Statute 559.715. Not a linchpin, and if it goes away, it's no big deal. But it's important in that you can make hay with it. You can make it useful to create, if you will, this doubt about the ownership. And here, my client did not receive, and I can say this without even asking my client, he did not receive notice of an assignment 30 days before they initiated legal action from the following. GE Capital Retail Bank, Synchrony Card Funding, Retail Finance Credit Services. Whoever Synchrony Bank gave the debt to, for that to be a true statement, all these companies, which are being hidden even in the bill of sale, would have had to reach out and done what they say he did. Clearly they didn't, because they don't want you to know about securitization because of the impact it has on their ability to buy and sell and then prosecute the debt against you. So that's not true. So that's in your counter affidavit, which is attached to this website video, as always. I'll also add the complaint of MCM, all the documents they're using to prove they own the debt, or they don't own the debt. They'll all be attached along with my show notes. But there's more. To support the DREC that does not prove anything, they mention documents in that paragraph 4, and one of them is Affidavit of Sale of Account by Original Creditor. So Shazam. And that is further proof and truth that GE Capital Retail Bank and Synchrony Bank did not pass this on to MCM, not just because it says that. On or about 10/12/2023, Synchrony Bank, formerly known as GE Capital Retail Bank, sold a pool of charge-off accounts, not a debt. My client's name's not in anything. Where are the other entities, if this statement is true, from the bill of sale? If this person, Alexa Stubbs, who claims to have access to the creditor's books and records, and she and states that the statements above are true to the best of her knowledge, wouldn't she include everything in the bill of sale, which clearly is in the books of records, because she's quoting the date of the bill of sale? Why is that? Is it an accident? There's no accidents in debt collection. There's only how they seek money and how they deceive. There's no accidents, all right? Also, this thing is notarized, but it's not sworn to. There's a distinctive difference there. An affidavit has to be notarized, your signature, that you recognize the signer. This is the notary saying this. And they're swearing under oath that the above is true, all right? There's nothing in here that says this person, Stubbs, is signing under penalty of perjury, which you must do, I believe, in the state of Florida and certainly in federal law for this to be a proper affidavit. Why am I saying that? Just watch. So under oath, no. And again, I say, where are all the other sellers? Now they do a weird thing. And I told you at the beginning how I've seen other MCM cases, so I'm used to it. They always attach that I talked about in terms of insecurity. If you are insecure about what you're telling someone, I'm not saying lying, you have a tendency to say too much. The truth takes a minute. The truth takes a sentence. But here they keep adding documents saying, you know that thing we just said? This guy here is saying, yeah, that's true. That's what the affidavit account was. And then there's someone else going, you know that affidavit account that was saying that other thing is true, the bill of sale? It's really true. So it's a piling on of, and it evidences an insecurity. So Cindy, put up the attorney signing, because it's an attorney signing, it's true, right? Shazam, the evidence of the certificate of conformity. This is weird. Here's why it's weird. This is a supposedly, and I checked it out, this is a Florida attorney, and it is, the gentleman's name is Tyler Burrich, and he's saying under Florida law, he or she is a person duly qualified to make this certificate of conformity pursuant to Section 299A of the Real Property Law of the state of New York. See what I mean? This is what happens. What does real property law have to do with the collection efforts of MCM? This is Florida. So I went and checked this guy out, and 3 things are true. Put up those 4 things actually. Shazamski. There is a certificate of conformity from a Florida attorney who's quoting real property law of New York. This has nothing to do with the confirming a sale of accounts, especially given the attorney's statement that his certificate is made in conformity pursuant to 299A of the real property law of the state of New York. This is a collection case. I'm quoting from my counter affidavit, as you should too. Thirdly, I could not find Tyler Burrich listed in New York as licensed in New York. If you're going to spout New York law, you better be a New York lawyer. I can't think of any reason why they just did this. It's dumb, because I think people are so fast. They go, oh, certificate of conformity, account affidavit. You are smarter than that. You go into details and you plunk it into your counter affidavit. Plunk alert. Also, an attorney should know better. This is not sworn under oath by the signer or affiant, which is Mr. Burrich, as required by federal and Florida law. Yet he's saying in his statement, it all follows Florida law, New York law. So that's a whole plate of wrong. I'm allowed to say that once a video. So I looked at the Fair Debt Collection Practices Act. I know it by heart. I didn't look at it, but that's what my client's affidavit says. And I'll do this. 1692I, 15 U.S.C. 1692I says there's only 2 ways you can be sued in the district you reside in, or if you own property or you sign the document that they're suing you upon in the district they're suing you in. So if he had signed it in Montana, they sort of could sue him in Montana. This is in Dade County, so if he'd signed the document in Seminole and they sued him in Seminole, they can get away with that under 1692I. None of those things applies. So he has a federal lawsuit against them. They may end up paying him more than they claim he owes them. And your old friend, the mini Miranda warning, is in the lawsuit. Cindy, show the first page and only page of the MCM lawsuit, Shazam, on the bottom there. Again, I'll repeat this. I try not to be boring, but it's purposeful so it sticks to you. First of all, lawyers have a tendency to volunteer too much to cover their own bleep. So that somebody is placed, please understand this communications from a debt collector. It's an attempt to collect a debt, and any information obtained will be used for that purpose. That's not required under federal law to be on any lawsuit, and under state law. Placing it on there, someone's protecting their butt, and that's the law firm. But under 1692G, a lawsuit or pleading is not considered a communication for the purposes of of triggering your debtor's right to have validation requests made, or all your rights under collection law sent to you. Pleading doesn't do that. But when you do this and say, this is a communication from a debt collector, your immunity under 1692 GD disappears. And the funny thing is, the very thing that requires the mini Miranda warning to be on a collection communication, 1692 E11, says, don't do this on a pleading. This is what they do. But the lawyer is doing the math and going, yeah, but I'm protecting myself, client be damned. Maybe they're doing that, maybe they're not. I don't know. But you plunk all of what I just told you right into your counter affidavit. You plunk it right into your answer and counterclaim. See my videos on plunking and linchpinning. Plunking and linchpinning. This is an MCM video, and all my debt collection videos, UHG, Crown Asset Management, PRA, that's a lovely one, Portfolio Recovery Associates, and MCM, done them all. There's plenty on there. Have fun, have at them. All this means my client not only doesn't owe this debt, because there's no proof he does, and the linchpin has been totally destroyed at this point, so the lawsuit should be dismissed. All that goes into your counter affidavit, as I said, but all that goes in a email from me to the other side. So I always give you these little emails, so when you set yourself up, you can maybe use these as a framework, and I'll give you snippets. MCM has filed a lawsuit against my client in the wrong court. Your client is aware of this because they've sent him letters to the Aventura address where he lives in. I don't know why they sued him an hour down the road when they had his address. And he didn't sign up for the debt an hour down the road. You refer to predecessor and interest. That's not an adequate substitute for actual names and assignments. Lynn Fisher, she has no authority to sign. You've also added the mini Miranda warning under 1692E11. You can't do that. And if you do, you do it at your own peril. And I quote, except this paragraph shall not apply to formal pleadings made in connection with a legal action, which is a lawsuit. In that vein, please forward me the validation and verification of this debt, because I'm saying you've initially contacted them. They got 5 business days to send me verification. And send me proof that all 5 entities in the bill of sale have a right to pass along and receive the debt and eventually become sellers. You state in your paragraph 5, plaintiff notified defendant of the assignment more than 30 days before the initiation of the legal action. In Florida, there's a requirement that you do that. I don't know if this attorney knows it. If he's watching, he will. Every case in Florida where someone says, hey, he didn't give me the notice, the court says, doesn't matter, it's harmless error. So I don't know why they did that, but it hurts them because now I say, please send all the notices of assignment from all the entities in the bill of sale. An impossibility because this thing was cut up, sliced and diced in securitization, which they were trying to hide, but essentially opened up the door wider for you and for me. In short and respectfully, the case is a mess and filed in the wrong court. Prior to my filing a counterclaim, my client is exercising his rights under federal law with the FDCPA and the FCCPA, which is actually stronger. It is. The FCCPA is Florida statute. I would ask that you agree to an immediate dismissal and mutual walkaway. So that's what you do. You linchpin, you find out, and you bore in on this thing that if it goes, it all goes. And that was our paragraph 4. I showed you how. All my counter affidavit, the counter affidavit connected to this video, my actual answer, where I took all that I just told you, put it in the counter affidavit, and plunked it into the answer and affirmative defenses, and will end up in my counterclaim if they do what they usually do, which is ignore me until now they have to pay me a check, We'll also, that goes all into all your pleadings. I'll add the answer, I'll add my show notes, I'll add their silly lawsuit so you can see for yourself how bad it is. And you may see a video soon on how I sued MCM for suing my client in the wrong district. All right, hope that helps. On a side note, we're a day away, I'm in my Florida office from Hurricane Milton, Uncle Milty, arriving here, and they just sent out evacuation orders. Never had that before. Usually we just laugh, but they're actually sending evacuation orders to where I'm at right now. So I'm squeezing this video as fast as I can. Hope to see you soon, and I haven't floated away. Thank you very much. Bye.